Continue with our examination of the rules and theory of human rights law. This is the second part, and we'll take a closer look at the entrenchment debate. Okay, so in 1998 we had the HRA, and this made the rights in the European Convention on Human Rights, the ECHR, directly enforceable in the UK courts. So entrenchment then, it basically refers to how easy or hard it is to change a law. So entrenched laws are protected by extra steps. They're really bedded in. So they're going to need something like a referendum or a supermajority to amend them. You can think of entrenchment a bit like having a locked box for your treasures. If you keep your valuables in an open drawer, well, anyone could move them, couldn't they, or change them with little effort. But if you put them in a safe with lots of locks, only someone with the right keys and perhaps permission can access or alter what's inside. So in law, entrenched rules are locked away, requiring more than just a simple majority in Parliament to be changed. And this might mean needing a public vote, referendum, or an agreement from a much larger group of MPs, and making them harder to tamper with compared to ordinary laws. The difficulty here is that the HRA, the Human Rights Act, it's not entrenched. It's not in the locked box. So Parliament can change or remove it with a simple majority. This flexibility reflects parliamentary sovereignty, but it also means rights protection in the UK can be less stable than in countries with written constitutions like the US. Now let's explain the different ways that human rights are protected under the UK's constitutional system. Well, here's a breakdown of each point. First, we've got statutory protection. So this refers to specific laws passed by Parliament, such as the Human Rights Act and the Equality Act. And these laws spell out particular rights and protections, like the right not to be discriminated against at work or when using public services. In other words, Parliament has written these protections into the law, so individuals can really rely on them in UK courts. We've also got common law. So before many rights were written down in statutes, well, UK courts already recognised important rights through judicial decision, which we know is common law. Examples include the right to a fair trial or the right to remain silent. Even today, common law rights can still help fill in the gaps where no specific law exists, and that provides extra protection for individuals. We also actually have some international obligations. Now, the UK, we've agreed to follow certain international treaties, such as the European Convention on Human Rights and the UN Convention on the Rights of a Child. These agreements will then influence law in the UK and government policy. Sometimes if a person cannot get justice in UK courts, they might be able to take their case to an international court, like the European Court of Human Rights. You can picture the UK's human rights protection, if you like, as a sturdy house. So the bricks are the statutory laws, written down, solid, like the Human Rights Act. Then we have common law rights, which make up the supporting framework. And finally, we have international obligations, like the European Convention of Human Rights, which form the roof. And altogether, these layers provide strong protection. But Parliament can still renovate or change any part of the structure. So it's robust, but it's not totally permanent. Parliament can change or remove statutory and common law rights, and international protections really depend on the UK's ongoing agreement to follow those treaties. So although there are multiple layers of rights protection, all are ultimately subject to change. Let's take a closer look at the European Convention on Human Rights. It was drafted after the Second World War to prevent those dreadful atrocities committed by the Nazis ever happening again. And it sets out a list of rights, which include, as you can see here, you've got the right to life, the prohibition of torture, the right to a fair trial, respect for private and family life, freedom of thought, conscience and religion, freedom of expression, and freedom of assembly and association. And finally, protection from discrimination. So if someone in the UK believes their rights under the European Convention on Human Rights have been violated, well, the first port of call is to try and resolve the issue using all the possible legal avenues within the UK, starting with the UK courts. It's only when there's no further option left nationally in the UK, meaning every single legal route or appeal has been tried and failed, only then can they take their case to the European Court of Human Rights, which is based in Strasbourg, France. This international court reviews whether the UK has breached the rights protected by the Convention and then can issue rulings that the UK government is expected to follow. So the UK was actually, interestingly, among the first countries to sign up to the Convention and was heavily involved indeed in creating its rules and principles. And this shows a real early commitment to the human rights in Europe. The Human Rights Act really changed things for people living in the UK. Instead of having to go all the way to Strasbourg to fight for their rights, people can now take their cases to the UK courts and get justice closer to home. What's more, the Act makes it crystal clear that public authorities like the police, the schools, local councils, they have to respect and protect these rights in everything they do. It's made asserting your rights much more straightforward and put the responsibility on those in power to do the right thing every day. So, rights enforced in UK courts. Before 1998, people often had to take their cases to Strasbourg. That was pretty costly and slow. So now UK courts can grant remedies for breaches of human rights directly. Good thing. Public authorities must respect those rights. All those public bodies that we mentioned, schools, councils, police, they have a duty, a legal duty to act. So, and if they don't, individuals can hold them accountable. Finally, we also have declarations of incompatibility. So if a law contradicts the European Convention of Human Rights, UK courts can declare it incompatible, prompting Parliament to review and potentially change the law, although remember, courts cannot overturn acts of Parliament. A couple of notable cases which we mentioned in the first video. So you've got Daly versus Secretary of State. This was where the court ruled that searching prisoners' legal correspondence breached their right to privacy. So that established restrictions on rights must be reasonable and proportionate. We've also got the A versus Secretary of State for the Home Department. The House of Lords found that indefinite detention without charge, even when it was a national security issue, was unlawful and it breached the right to liberty. And finally, the other case we mentioned, the Hurst versus UK, and this was where we had that blanket ban on prisoner voting, which the UK decided breached the right to free elections under the European Convention of Human Rights. So it sparked a real debate actually about the balance between national sovereignty and European oversight. UK Bill of Rights, let's have a look at some proposals and debates. Start by thinking about this. What would happen if the UK just decided to get rid of the Human Rights Act 1998? And indeed, some politicians have suggested that we should replace the HRA with a UK-specific Bill of Rights. So some supporters for this say it would better reflect British values, and it would tailor rights to the UK's traditions and give Parliament more control over rights law. But critics point out that this could weaken human rights protection, make rights more changeable, and also reduce the UK's commitment to international standards. Well, the debate continues, and any change could significantly affect how rights are protected in the future. Moving on to a few criticisms of human rights law. Let's start by talking about judicial overreach. What does that even mean? Well, overreach means courts going too far, basically making decisions that should be left to elected officials instead of judges. Now, sometimes courts are seen as making decisions on political or moral issues, things like privacy or prisoner voting, as we've seen. And some argue, well, that really shouldn't be up to judicial precedence. It should be left to Parliament. Another criticism is foreign influence. So the European Court of Human Rights basically can overrule UK courts. And some people see that as pretty undermining of our national sovereignty. But is this the kind of oversight we want for our legal system, they say? Should decisions about British rights stay solely in British hands? Next, we've got issues of complexity and cost. I mean, human rights cases, they're often really complicated and can even take years to finish, making it hard for people to get justice. I mean, that case we mentioned, the Hearst versus UK, took absolutely ages. It took years before the case reached the European Court of Human Rights. And finally, abuse of rights. Sometimes human rights laws are misused. Famous case was where public figures have used privacy rights to stop the media reporting on alleged misconduct. And therefore it's not being used to protect personal freedoms, but to avoid scandal and scrutiny. I mean, if you do a bit of research on that, look up super injunctions and you'll see. Let's just mention devolution as well. So the Human Rights Act is actually written into the constitutional arrangements of all of the devolved governments too. So, for example, Scottish Parliament can't pass laws incompatible with European Convention on Human Rights, and Welsh and Northern Irish governments also, they have to comply. Devolved bodies actually sometimes go even further to protect rights. So Scotland, for example, has proposed its own human rights bill to expand protections beyond the European Convention of Human Rights. And this means that even if human rights protections change at Westminster, devolved nations can actually maintain or even strengthen local rights protections. Law, society, morality and justice. So human rights law is shaped by society's changing values and ideas about what's fair and just. So some example, attitudes towards equality and privacy evolve as technology is always changing. And because that evolves, so too do the laws protecting against discrimination and surveillance. So, the Data Protection Act, which was brought out in 1918, and this updated privacy laws to give people greater control over their own personal information. It's a good thing too, isn't it? And it was a bit of a response to people becoming more and more worried about the advances in technology and becoming more concerned about things like surveillance. So these legal changes really reflect society's shifting views on what fairness and privacy mean in the modern world. Similarly, lawmakers and judges must often balance competing interests, such as freedom of speech, but also protecting from hate speech. And they've got to use moral and ethical reasoning alongside legal rules. And this makes human rights law a real living, dynamic, ever-changing area that responds to society's needs. So, key message for you, human rights law isn't just about what's written in the legal books. It's about how we protect people, create a fairer society, and respond to the challenges and needs of a changing world.